Hi, everyone. I'm Paul Coble, Chair of Intellectual Property and Artificial Intelligence at Rose Law Group. One of the hottest topics in artificial intelligence today are digital replicas, also known as deepfakes. Deepfakes are fake images of an individual that appear to be real, but often portray that individual in a context or in a way that they didn't want to be portrayed. Deepfakes are not anything new. They've been around for quite a while. In fact, previously they were just called Photoshop images. But the new wave of generative AI technology has made it far easier for individuals with less technical knowledge to create much more realistic fake images and video much easier. So with that in mind, the Copyright Office recently released part one of its report on copyright and artificial intelligence. And part one of this report is intended to focus on the impacts of digital replicas in the digital media space. Today, I thought I'd go through some of the main takeaways from that part one of the report. So first, the Copyright Office started by defining what is a digital replica. The definition that the Copyright Office came up with is a digital replica is a video, image, or audio recording that has been digitally created or manipulated to realistically, falsely depict an individual. So a couple of things to note about this definition. First of all, it applies to all types of media, video, image, and audio recordings. Second, it applies to, it requires that the media be digitally created or manipulated. But the third is that digital creation or manipulation is not tied to artificial intelligence. So this includes the traditional Photoshops as well as images that are created or edited using generative artificial intelligence technology. So with the definition of digital replicas in place, the Copyright Office then identified three distinct harms. And these are harms that I think most people are familiar with and have generally identified as being problematic with deepfakes. The first is the creation of explicit images of individuals. These are typically sexually explicit images, but can also occur in a wide variety of explicit or violent situations in which the individual does not wish to be portrayed. The second type of harm are the use of digital replicas to perpetuate fraud. And this we've already seen in a number of types of instances, but as digital deepfakes get better and better, and we are seeing technologies such as live video deepfakes, the applications and potential for the use of digital replicas to perpetuate fraud is only increasing, and the applications in which we're seeing that type of fraud come across is more frequent. And then the third type of potential harm for deepfakes is the potential to disseminate false information and undermine public trust and the political system. I think that we've already seen these types of deepfakes in the past be used to perpetuate all three of these types of harms, but the widespread and ease of generative AI technology is only going to make these harms exacerbated. So that led the Copyright Office to examine the applicability of our current legal framework to see how the current legal framework is currently set up to and prepared to deal with the onslaught of digital replicas that we're starting to see. Some states, such as Louisiana, New York, and Arizona, have already enacted laws to specifically target and deal with deepfakes in the era of artificial generative technology or generative AI technology. These laws have had varying degrees of success. I've written in the past about Arizona's deepfake law and how I believe it is incredibly ineffective, both in its drafting and in the fact that it allows for an incredibly long 3-week grace period before the law comes into effect, where that admittedly harmful material can continue to be posted and spread for up to 21 days before the law prohibits or comes into effect and imposes consequences. So the states have had various degrees of success with their anti-deepfake laws, but they're certainly not widespread or or uniform across all of the states. Absent these new state laws, there are only a few types of federal and state laws that are applicable. Copyright law, the Lanham Act, which is generally targeting trademarks and trade dress, commercial protections, and civil libel laws. Copyright law, to take that first, because this is the Copyright Office's report, generally does not protect replicas, although there might be some copyright infringement involved in the creation of the replica. If the replica is sufficiently different from the underlying source material, copyright is difficult to use to protect against those types of deepfakes. There are a number of cases that are currently working their way through the courts that may curb this. So I think the Copyright Office may have been a bit premature to throw out all potential for copyright to protect against or to be applicable in the digital replica realm, but it's certainly not a perfect vehicle for protection. Similarly, the Lanham Act protects against the misuse of an individual's name, image, or likeness. This is, importantly, it's applicable to all individuals. There's no level of fame or it's not applicable to just celebrities. It is applicable to all individuals. However, it only protects against commercial uses. So you have name, image, and likeness rights, all individuals do under the Lanham Act, but they can only protect against commercial uses. So non-commercial uses are not actionable under the Lanham Act. And the last category is civil libel. Civil libel certainly can apply to many of the applications for damaging replicas, but not all of them. Libel actions typically require you to prove actual damages. There are some contexts where damages are presumed per se, but it's not all contexts, and there are certainly a wide variety of damages that we want to protect against that civil libel laws are not equipped to handle. Additionally, libel laws are enforceable really only in court, and civil litigation is a very poor and very slow mechanism to combat deep fakes, especially in the era of digital, the digital era, where these deep fakes can travel around the world very quickly and cause an incredible amount of damage. So the Copyright Office came to the conclusion that many of us intellectual property attorneys have, that the current legal framework is not prepared and is ill-equipped to combat the rise of digital replicas and deepfakes, especially in the era of generative AI. So we need new laws and new legislation to protect against this new types of technology. The Copyright Office stopped short of recommending any specific pending legislation, and there are a few bills that are out there working their way through the legislative process. But the office did provide a handful of recommendations, and I think a lot of them are pretty good and well taken. These recommendations, I think, we're likely to see then in future legislation, to the extent it's not already incorporated into existing legislation. The first recommendation, I think this is incredibly important, is that the potential right for digital replicas that the Copyright Office is proposing here needs to apply to all individuals. There can be no threshold level for fame, and it must apply to all instances, not just commercial requirements. And so this is to make sure that the digital rights or rights to one's own digital image applies to all circumstances that might be damaging, not just commercial circumstances, but also posts on social media. The Copyright Office also proposed that this right be limited and prioritized to living individuals. So essentially, your right to your digital persona would persist so that you were so long as you were alive, and then for in the neighborhood of 20 years after death. Allowing for some sort of natural expiration and not locking those rights up indefinitely, and allowing for telling of history. The Copyright Office's proposal as to infringement was not just limited to commercial uses, but for all public dissemination. And so this is kind of critical in that it is couched in the terms of public dissemination. So any posting or making publicly available would potentially infringe upon this use. However, the office also proposed some limited exemptions for legitimate private use. So uses that are not circulated, but the office was a little light on what it means to be a legitimate private use. So I think that is going to require some additional sussing out. The Copyright Office proposed that infringement of this digital persona right have some sort of actual knowledge requirement, meaning that in order to infringe it, you have to actually know that you are infringing, that it is a deep fake, or that you are infringing upon someone else's right to their digital persona. However, there would be some sort of secondary liability where, and the Copyright Office proposes that this secondary liability be modeled off of copyright infringement liability, which has a component to allow for willful blindness. So you can't just bury your head in the sand and continue publishing something that you really should know is a deep fake. Maybe it is wildly inappropriate. Maybe you know that this person never engaged in this type of activity, yet you're publishing it anyway. Those types of willful blindness would still be actionable underneath this type of secondary liability model. Additionally, one of the most, I think, interesting and most controversial, potentially, recommendations is that the Copyright Office believes that the right to your digital persona should be licensable, but not assignable, meaning that, and this is particularly applicable to celebrities and actors, actresses who may be asked to assign their rights to their digital personas in perpetuity. The Copyright Office proposes that would not be permissible, that you could only license the rights to your digital persona for particular uses, and that there would be additional limitations for and protections for the digital personas of minors. I think this is a really interesting proposal and makes a lot of sense. And we've already seen a lot of public discourse around the potential for perpetual assignment of these digital rights and collective bargaining agreements prohibiting that in particularly the context of film and entertainment. And so making those types of rights more broadly applicable to all individuals and not just to celebrities, I think has some potential interesting impacts. Additionally, and very importantly, the Copyright Office recommended that there be effective and proportional remedies that include both injunctive relief and damages. This is important because where you only have one or the other, there's often not sufficient mechanisms to quickly stop offending and infringing behavior, as well as make it a big enough deterrent in the form of those damages to prevent those damaging behaviors in the first place. And lastly, and critically, the Copyright Office recommends that the federal legislation on this topic not preempt state laws. And so states would be free to create their own laws that are that provide increased rights to individuals to their own digital personas. We haven't seen any particularized legislation yet that embodies all of these critical requirements, but I think that with the Copyright Office's report out there, we are likely to see more action on the state level, as well as increased legislation on the federal level, hopefully to enshrine some of these rights to your digital persona into legislation. So we'll be keeping an eye on all of those new developments in artificial intelligence and emerging technology law. Please follow along with Rose Law Group for additional developments in all of those legal news. Thanks.